actually penned an opinion piece, and you argue that the court's findings in the Pistorius matter and the state's meting out of its sentence might be unpopular. However, they are utterly in keeping with a consistent application of the current law. Meaning?
Well, just to clarify, that opinion piece was actually written a number of years ago now, and it was written when he was sentenced under his original culpable homicide conviction. And there was a lot of controversy at the time that after serving about 10 months of his sentence in prison, his sentence was being converted into one of correctional supervision. And I was simply explaining that under the provision of the law that he was sentenced for the culpable homicide conviction, that was a standard practice for the way that that sort of sentence would get managed. Having said that, I think the same is equally applicable in this case, meaning now his conviction has been converted to a murder conviction. He received the average sentence, the standard sentence that a first offender convicted of murder would receive, which was, although his ultimate sentence was 13 years and 5 months, they deducted time he'd already spent, so it would have been the minimum 15-year sentence that anyone would receive. And any person having received that sentence would fall to be eligible to be considered for parole after serving half of their sentence. He, in fact, on certain calculations, has served a bit more than half. So this is a completely standard procedure, and so far it is unfolding the same way that it would unfold for any other prisoner in his position.
Sure. Is this still applicable? You argue that where the prisoner has behaved well in prison, shows good prospects for rehabilitation, and is not considered to be a danger to society, it is standard practice to release them on correctional supervision at the 1/6 mark, because we heard from Singabako Ngumalo asked on what kind of a prisoner he is. He says that, well, Oscar Pistorius is an inmate who has been working quite hard. Aaron Bates mentioning that he's involved in the farming projects of the prison as well.
Absolutely. So the 1/6 doesn't apply because that applied to his old sentence. Here we would apply the 1/2 mark. But the same sentiments would apply. We have to remember that it's extremely costly keeping prisoners incarcerated, and those costs are borne by the taxpayer. So there is a very serious public interest when someone no longer poses a threat to society and they have been sufficiently rehabilitated, that they are able to serve their sentence outside and bear some of the costs of serving that sentence. It's also really important to remember in these discussions that parole is absolutely not the same thing as release, i.e. the end of a sentence. It is simply the continuation of punishment in the community. So the offender still needs to serve out the rest of their sentence that they were issued. He'll have to serve out his full 13 years and 5 months. But whereas for the first half and a bit, he's been serving it out inside of prison, he will now be serving his sentence in the community. And because of that, because it's not a release, but it's a sentence served in a different context, that is why we see very strict conditions attached to parole.
Sure. Kelly, we understand that the parole board, as we heard from Singabako Ngumalo, is made up of members of the community, the South African Police Services, the NPA, and only but one correctional services representative, and that would be the secretary. And these people are then tasked with also hearing the submissions of the Steenkamp family. And to my knowledge, they still do not want him to be released. So this balancing act, how do you perceive then this is going to impact or his prospects for freedom, if you will, partial freedom?
Well, the parole board will always be guided by the Correctional Services Act and their duties as stipulated under that act and accompanying legislation. And their primary aim is to ascertain whether this offender is suitable for correctional supervision, whether this offender would pose a risk to society, whether he's been sufficiently rehabilitated. The submissions of the victim's family, in any case, are of course relevant to that and important to take into account and weigh in the balance. But they can't be the sole determinator of the outcome, because that would not be in keeping with what the parole board are tasked with deciding. They have to decide whether this person is an appropriate person to be punished in the community rather than in the institution. And of course, it won't be surprising to know that it's not uncommon for a victim's family to be against parole. I would say more parole hearings than not, where there are submissions from the victim's family, they would be against granting parole. So this is something that parole boards have to contend with frequently in a common basis. And they will be well rehearsed at sensitively weighing up all of the competing factors in order to determine what they ultimately need to determine, which is whether this person has been rehabilitated and is a suitable person for placement for community punishment.
Sure. I'm particularly interested in the members of the community's involvement in them being selected to make up the parole board, especially when we speak of impartiality. Yes, they must be guided by the principles of whatever laws prescribe for the parole conditions or parole to be handed out. But do we know how they are selected and vetted?
Well, that would be the internal processes of the Department of Correctional Services. It's very common, first of all, for those members of the community to be selected because they have some specific skills to offer in this process. So, for example, social workers, psychologists, community workers, people who work in community centres, that sort of thing. It's true that any member of the public can put themselves forward, and that's important because we want justice to be transparent, we want it to be accessible, and we want members of the community to have a stake in the justice that gets meted out. But once they have been vetted and they're deemed to be appropriate to form part of that board, they would go through training, they would be exposed to all of the relevant legislation that they need to learn and take into account and be guided by. And of course, in order to really have a safeguard that these processes are happening according to the law and unbiasedly, there are opportunities to review or appeal decisions of the parole board, and that is the safety mechanism that is built into the system.
Thank you so much, Kelly, for your time this afternoon. Kelly Phelps is a senior lecturer at the Department of Public Law at the University of Cape Town.